It's commonly misconceived that a song only has one copyright in it, but there's two. You have the composition copyright, which is sometimes called the musical work, but it's like the melody, the lyrics, harmony, the songwriting, essentially. And then the second is the actual sound recording copyright. So the music as it's fixed in a recorded medium, essentially. So that's sometimes called the master. And, different people own or control those different rights. So it's really important to know if you're seeking permission, you might need to have to contact multiple people. There might be even multiple people who even own one of those copyrights. You might have multiple songwriters on one song, or you might even have within those copyrights, there's different subsections of rights. So one collecting society might control some portion of the rights, whereas a music publisher might control some portion of the rights of the same composition. So it can get very complicated from a licensing point of view, and from a songwriter point of view or musician point of view I guess it's important to be aware of like what you're creating and the different rights that exist.
Mixcloud.
The Inside Track.
Hello, everybody, and welcome to another episode of The Inside Track. I'm your host, Nico Perez, co-founder, CEO at Mixcloud, and I am very excited today to be talking to somebody who I've known for, I want to say like maybe nearly a decade or something like that. Mr. Aneesh Patel, straight out of London, and we're going to go deep on the topic of copyright in this episode. And hopefully by the end of this episode, everybody who's listening will definitely have a very solid understanding of how it works, what the origins of copyright are, and most importantly, what you should know if you're a DJ, if you're a radio presenter, if you're an artist, band, or maybe even thinking of starting a record label. So, Aneesh, it's really great to have you on the podcast. It's been a long time coming. Welcome.
Thanks for having me.
Yeah, and I think it'd be really great to start with a little bit of your background, how you got into this world of music law, music licensing, working as a lawyer. But also, I really wanted to kind of let people know that you're involved in many different music endeavors in London, co-owner of an amazing hi-fi listening bar and also a restaurant called Brilliant Corners. It's in Dalston. If you happen to be visiting London or listen to this from further afield. Also, Giant Steps, a sound system and sort of traveling event party, and Moo and Om, two of your other new venues that maybe people don't know about yet, but also kind of located roughly around kind of northeast London. Is that right?
That's right. Yeah. Well, Brilliant Corners, Om and Mew are all on Kingston Road, about 100 meters from each other, so you can do a bar crawl all in one night.
Very convenient neighbors. So yeah, well, I'd love to hear kind of like where did this musical journey start for you?
Yeah, I mean, I think the musical journey obviously probably goes back to when I was a kid, I guess, and I think not necessarily, I wasn't a kid who had parents who had tons of records and listening to lots of, versatile types of music. Actually, my parents kind of had quite terrible taste in music. My dad would be like blasting out Celine Dion, like My Heart Will Go On, in the sound system at home. But he did always have he always had like kind of the latest sound gear and was always kind of like talking about the quality of sound and things like that. So I think that did sort of filter down a bit to me when I was a bit younger. And probably in terms of like the different possible like, genres and things like that, I think a lot of that started probably from like following Michael Jackson a lot when I was a kid. Our family was obsessed. There's so many different genres and like types of rhythm and production in all of his albums. But, and then I think, like I'm Gujarati, I think many other Gujarati kids of my generation will relate to, the career options that were acceptable to your parents weren't necessarily as broad as they were maybe for other people. So I remember looking at my university options and my parents, I was like going through the list. I was like, can I do sound engineering? They're like, that's not a career. I even got to like biochemistry because I was like, I like science. They're like, that's not a career. And they're like, you can be a doctor. And I was like, that's pretty much it. And they were like a pharmacist, they were pharmacists. And I was going through the list and they was like, no, no, no. And I eventually got to law and I was like, law? It's like, can I do law? And they're like, law. Yeah, okay. That sounds okay. That sounds like it would be a thing that wouldn't embarrass us to our other, family members. Yeah, exactly. Yeah. So even though, I was doing like all science and maths for A levels, so did not make sense at all to start, going deep into the English language with law. And actually, if anything, when I did get to university, I struggled a bit because most people studying it were like doing history and in English literature and things like that. Whereas like, I wasn't so strong on that. But in my mind, I was like, this keeps my door open. Law touches on so many different industries. I was like, keeps my doors open in terms of what I actually want to do later in life. I don't need to decide right now. I can keep my parents happy and I can figure out what I really want to do later in life. So I kind of carried on down that route and, ended up working in a city law firm for a bit. My brother did a similar thing. He was actually working in a West End law firm and we were both, not enjoying it, to be honest, just grinding it out, but still I had that hunger, like, what am I really passionate about? And I knew I wanted to work somewhat in music, but I just didn't really know how to get there, trying to get a job.
So when you were working at these kind of city law firms, was there any kind of music law or copyright law involved, or was it kind of more general?
I mean, there was it did touch on copyright law. Like the firm I worked for I did a secondment to MTV. So, but at that time, MTV wasn't really music television anymore. It was like Geordie Shore and, stuff like that. So there was there was occasional kind of music related, copyright related issues, but it wasn't like proper music law yet. And I found it quite hard to try and to get a foot in the door with the hardcore music law firms. It seemed like you had to know someone or you had to have relevant experience. So, so I somewhat gave up on that route, that like music law being a route to get closer to the thing I was really passionate about, being music. But I wasn't a musician because I'd never prioritized learning an instrument or anything as a kid. So, I felt like, how else can I get closer to that industry? Maybe becoming a music lawyer. But at some point I sort of gave up on that. And my brother and I decided to both sort of bail on our jobs as lawyers and to open, we had started going to some parties, like one Beauty and the Beat in London, and which ironically, the first one I went to is actually where Ohm is currently situated now. So
wow.
So it was the first time I think the first time I heard a pair of Clipshaws was like at their party, and I realized that they were then part of Lucky Cloud, which was a group of people who were bringing over David Mancuso and organizing the Journey Through the Light parties at the Light Bar in Shoreditch. So then that was like, our first real introduction to that whole, learning about the history of all of that, how far it went back. And, our first experience with learning about that, all that type of sound system and the speakers and the amplifiers and all the equipment. And, helping out like with a lot of those parties, volunteering to take down some of the equipment. And yeah, at that point, I think we were in the back of the van of one of the Beauty and the Beat parties, like dropping the sound equipment back at someone's house at like 5 or 6 in the morning. And I was just like, feeling pretty tired. I was like, is there a way that we could just like rent somewhere and just leave the speakers in there? That was kind of the first inception of it. And yeah, it sort of led to chatting to my brother. I was like, you know what we should do? Like, let's just like, we should quit our jobs and open a bar and like just put all the things that we love in there and make it a place that we can hang out with our friends and like-minded people. And if it doesn't work out after a couple of years, at least we did it. It would probably be a fun experience. And then we'll just go back to our other jobs. So yeah, but I think interestingly, like it somewhat opened the door to actually. So, I mean, after a few months, we weren't really making any money and it was quite difficult, as any startup is. I'm sure you know that in its early stages. And you're just trying to find ways to get by. So, we were like, one of us got to go back to law. My brother carried on sort of running the operation. I went back to trying to find a job as a lawyer. And then I saw an opening as a music lawyer, and I managed to get an interview. And actually, I pretty much spent the whole interview talking about Brilliant Corners, and they were like, wow, so you've got all these. And by that point, there was a lot of like label events happening, and we were doing kind of quite cool album launches with like quite a lot of big artists, and guest DJs were popping up there that a lot of people knew about. So the law firm was like, they were really excited about like me coming on board. I think at the end of the interview, I said, do I need to know anything about music law? And they were like, do you know how many types of copyright there are in a song? And I was like, yeah, I know that. And they're like, that's all you need to know. You can figure out the rest. I was like, okay, cool. Which I guess we'll come on to later on, how many types of copyright in a song. And that was kind of the journey back into becoming a music lawyer. So I was at this firm for some number of years. I think that's probably where I started working with you, and I started to do a lot more sort of licensing for platforms. I realized that was it was a new area in terms of, there weren't many lawyers who know how to do that kind of work. And maybe a couple of lawyers were kind of monopolizing that practice area. So I tried to make a big focus of schooling up on that area and try to improve my knowledge on that, whilst also doing a lot of the traditional stuff like record deals and management deals and stuff for festivals, and so the full breadth of kind of music work. And then I guess after I went in house for a little bit, and then after I felt like I had enough experience, I just decided to go independent. So start my own independent practice, work with people who I like to work with, work flexibly. Allow enough time for me to still also work on the side projects with my brother, all the venues, which I still like, I'm very passionate about. But yeah, I mean, I think working independently and on the things that I care about, the artists that I like, the platforms I like to work with, has sort of turned its head on like what I originally hated as a career. Like I really hated being a lawyer. I hated sending out the bills. I hated the time recording. I actually didn't really get along with the people always either. It just wasn't. And, I hated wearing a suit and going into the city. I managed to now not have to do any of those things. I work with people that I like, businesses that I think I believe in, and artists that I believe in. Don't have to wear a suit anymore. I don't have to get on the tube anymore. So it's all great. And there is, I think it's been kind of an exciting, interesting journey back to really kind of enjoying positive sides of this profession.
That's amazing. Very inspiring, I think, to kind of forge your own path like that. And I was wondering, is there kind of like a thread of like jazz that sort of weaves through quite a few of these things? Because I think you've hosted quite a few jazz events at Brilliant Corners, also with Moo. And you mentioned kind of just before the call that you kind of do some copyright 101 stuff for jazz musicians.
Yeah, I think there was, like, trying to trace back, it's quite a long time ago. So we're trying to trace back, the origins of the jazz. All of the venues are named after jazz albums. So Brilliant Corners, the Monk album, Giant Steps, Coltrane, Coltrane. Mew is Don Cherry. Idle Moments, Grant Green. And the reason for that was like when I'd started like going to the sort of the Lucky Cloud parties and learning about cliptrons and stuff. I was still at uni and I bought a pair of Klipsch La Scalas, which are like the one tier down from cliptrons, which we still use today at Giant Steps. So it's like, 20 plus years later, they're still going strong. If you ever go to Giant Steps, they're the ones at the front. And I couldn't, they were actually too big to fit. I maxed out my student credit card, and I think I probably, used my brother's as well or something, and borrowed my money off my mum. They weren't even that expensive, but I had like a £250 limit on my student credit card. So, and then, but they were too big to get through my front door, which was pretty devastating. I was just like, spent all this money. They didn't fit through the front door of my flat. So we had a friend who had like a wine shop on Cackney Road. And I was like, as painful as this is, can I put my speakers in your basement for a while? Like, and you might have the amp and everything. but like, can we do this thing once in a while where we sort of come and listen to an album like in darkness, like from start to finish? And I think the origin of that was kind of like going to house parties, and we'd be listening to all, like loads of different types of music and dancing and stuff like that. And at some point, I think, you know, maybe credit to my brother, he'd be like, look, should we get a bit more serious here? Should we just like stop dancing, just turn all the lights off and like listen to like a serious jazz album? Let's listen to like A Love Supreme in the Darkness and just learn something about ourselves, you know? And we're all a bit like, what? Oh, we're having a fun time like dancing. But yeah, maybe we should actually try it. And then, you know, you'd listen to the album and be like, wow, that was actually pretty profound, you know? So anyway, we started doing this thing at this wine shop where we would introduce an album, probably that we didn't even know ourselves, talk about its origin, where the time and place it, you know, a bit about the musician, and then just listen to it in the darkness on this, my sound system. And I think the last album we did was Brilliant Corners. Like that was the name, that was the last one we did before we stopped doing them because the shop closed down. And then, you know, that was kind of the inception of, shall we open a venue with this kind of sound system, you know, as well as the sort of experience of the parties. And yeah, for some reason, and because the Clipshaws are like corner speakers, they have one of the unique things about them, they sit flush into the corner and they use the corner to reflect bass. They use the walls to extend sort of the length of the horn for the bass driver. And then plus that being the last album we did for that thing is, plus I thought, you know, it's just a kind of quite a beautiful name. We settled on that name. And then once we named one after a jazz album, we're like, let's just, Giant Steps came around. I was like, Giant Steps, that's quite funny because it's like a bigger version of Brilliant Corners that we move around, you know? so we just kind of stuck with the theme.
Amazing. Thank you for that little bit of history. Love it. It's funny because like now there's listening bars and hi-fi bars and things like that kind of popping up everywhere. But I feel like you guys were very, very early to that.
Yeah, it's true. We were actually the first one in London. I mean, I think now we don't even get name checked in the top listening bars in London or whatever because we're so old that people have forgotten about us. But I mean, like one of the first, I think, really, I don't think there were many even in the States or even across Europe, to be honest. Like it was 13 years ago.
Yeah, obviously Japan, different story. But,
Japan, yeah, obviously.
Maybe we'll save that for another podcast.
I think, you know, nothing's original. Everything is borrowed. So, you know, we didn't come up with the idea. It was obviously everyone takes inspiration from someone else.
Well, that seems like a perfect segue to the meaty topic of copyright that we'd like to talk about today. And maybe I think it'd be cool to kind of maybe start at the beginning. So conceptually, you know, what were the kind of origins of copyright and what were the words founding fathers or anything like that, but what were the people who kind of came up with this idea of copyright? What were they trying to get at? What was the origin story? Yeah,
I guess like other intellectual property rights, although they all differ slightly, like patents and trademarks, the general premise is to incentivize creativity. So, you know, by giving the creator like a temporary monopoly over their work. So, you know, if you write a song, write a book or a film, the law basically says you can control who can copy, distribute, or monetize that piece of copyright for a certain period of time. And period of time differs country by country, actually. You know, there's no set amount, and it differs by type of copyright as well, which is interesting. Interesting who came up with the, you know, economic analysis of how long a copyright should subsist for a particular type of, you know, work. But, you know, there is some sort of general consensus on that. But yeah, essentially, for whatever reason, it was determined that like a sound recording in the UK, the owners of that sound recording should have the exclusive rights to it for 70 years from the date of its release. But for a composition, I guess we'll come on to the differences there. It's actually 70 years from the death of the composer, so it's significantly longer. I think basically the balance is creators get rewarded, but eventually the work has to fall into the public domain, meaning anyone can use it so that culture continue to evolve and build on what's come before.
Amazing. And so you mentioned it there, you kind of hinted at it, that there's these sort of two different parts to any song that is made or put out there or released: the musical composition and the sound recording. So what should people know about these kind of two different parts? What do they mean? What are they kind of representing?
Yeah, so I think, it's really important to know, and probably why they asked me that in my interview question at that law firm, that, there's a commonly misconceived that a song only has one copyright in it, but there's two. So you have the composition copyright, which is, sometimes called the musical work, but it's like the melody, the lyrics, harmony, the songwriting, essentially. And then the second is the actual sound recording copyright. So the music as it's fixed in an actual sound recording medium, in a recorded medium, essentially. So that's sometimes called the master. And, different people own or control those different rights. So it's really important to know if you're seeking permission, you might need to have to contact multiple people. There might be even multiple people who even own one of those copyrights. You might have multiple songwriters on one song, or you might even have within those copyrights, there's different subsections of rights. So one, collecting society might control some portion of the rights, whereas a music publisher might control some portion of the rights of the same composition. So it can get very complicated from a licensing point of view, but from a songwriter point of view or musician point of view, I guess it's important to be aware of like what you're creating and the different rights that exist there, and therefore like what you give permission to or what you give away in any deals that you do.
Yeah, I think it's also quite useful to know that it sort of depends a little bit also on what type of music you might be making. So for example, in the electronic music world, very often the person kind of producing the song is also the same person they're writing the song, maybe the notes, there's lyrics. And they're also the person kind of recording it. So all the copyrights could be owned by one single person, one individual who may or may not be signed to a label. We can get into that later. But if you kind of go into the world of pop music, the Taylor Swifts and Rihanna's of this world, oftentimes there could be anything from like half a dozen to a dozen different songwriters who all contributed on the musical composition, the musical work side of things. So that's the notes and lyrics again. Is that right?
Yeah, that's correct. Yeah. So, and I think it's important to note that the creator, like, or copyright automatically subsists at the point that you create it and it's fixed in some sort of medium. So, in the absence of having an agreement on what the share of a songwriting splits are on a particular song, everybody is deemed to be automatically a joint owner of that property, intangible property that can be bought or sold or licensed. And similarly, on the master side, actually, it's slightly different. On the recording side, it's slightly different. It's actually, certainly under UK law, it's the person who put the arrangements in place to create the recording. So that's where it can get a bit confusing. So sometimes is it the producer? Is it the label if they organize a studio time? Or, it can be, it's not that sometimes performers think that they automatically own the copyright in that master, which is not necessarily correct. They do have separate performers' rights of their performance in that recording. However, they won't necessarily own the master if they want to get it released, for example. When you go down the sort of like, we do work with quite a few clients that like do reissues. There's quite often disputes between maybe the person who produced the track, 50 years ago versus the artist who's like, performed on it, and who's actually entitled to the royalties from that in the absence of a proper contract.
Does that vary by which territory or which country the contracts were done in?
I think it can do. There's definitely nuances, but I think that principle, is reasonably consistent. I mean, I don't know. Probably would have to check with a US lawyer on that. But yeah, it does vary. I'm sure it does vary. I mean, that's the thing. Like every copyright law is can be different. I mean, I think there's some level of harmonization across the UK and EU, but every territory is different.
While we're kind of talking about this topic of kind of the two different copyrights, maybe also worth kind of just talking to people about covers. So when you have one person who writes the song, let's say, Dolly Parton writes a song, they may be the songwriter and own the kind of musical work, composition. But it's actually possible, at least in the States, anybody can do a cover of that song as long as they kind of retain the original lyrics and everything. In which case somebody else might own the master or the sound recording, right? Is that correct?
Yeah, that's right. So anyone can make a cover as long as it adheres to the original melody and lyrics and structure. So to the extent that it starts to deviate, then it becomes an adaptation, which then does require permission. So I think the covers can be, the permission to do that can be obtained via it's sort of mandated to collecting societies, essentially. And that's why you can just make a cover, and when you register your cover, if you're releasing it, you just put 100% and then the original songwriter. So you would not retain any songwriting in that cover, of course. But then, yeah, to the extent that you start to manipulate the work, then you do need the permission of the original songwriter. But you could go out and make a cover of a song and own the master on the sound recording copyright, because that's a completely separate copyright. And as soon as you've fixed it, provided it features your performance which you've cleared someone else, you can own that sound recording. But every time that sound recording is streamed or otherwise exploited, the original songwriter will get paid from it, just as they would if it was their recording.
Yeah. So let's talk about streaming for a moment. One question that's kind of come up from time to time in running Mixcloud is we have DJs or radio presenters who kind of come to us and said, I bought these tracks legally. I bought them on Bandcamp or Beatport or wherever it may be. And so why should I need a license to be able to kind of stream, whether it's live streaming or kind of upload a recording of my DJ mix or set to the internet? So we'd love to kind of like touch on that a little bit and kind of expand on why actually a license is needed, either by the person uploading it or the platform that they're uploading to.
Yeah. So when you purchase music, download, or physical, you're only acquiring the right to use it for personal use only. So that doesn't give you the right to distribute it to many other people. So if you're uploading it to a service like Mixcloud, you need additional permission from the copyright holders to do that. Then the platform has a responsibility, if it is receiving uploaded content, the platform has a responsibility to then put in place licensing mechanisms so that uploaded content can be scanned and then royalties can be paid to the original rights holders. So yeah, there's, I guess, common misconception. I mean, similarly, it's kind of similar to how a lot of shops and, hotels and things play Spotify in the background in their lobby, but actually Spotify is licensed by all these different copyright holders for personal use only. It's not licensed for commercial purposes, actually. So it's a similar kind of scenario.
Yeah, and if anybody's listening to this and maybe they experienced a DMCA takedown or something like that, that is usually what happens when a platform like Twitch or YouTube or some degree Instagram, Facebook, places like that, if they haven't actually gone out and secured the licenses that they need for any particular sound recording or musical work, sometimes they will issue these DMCA takedowns. And that's because they're operating under this regime called the DMCA Safe Harbor, which essentially says you as a platform are somewhat protected as long as you respond and take down when a copyright owner comes to you and says, hey, you don't have a license for this. Is that kind of roughly right?
Yeah, exactly. That's right. To the extent that the platform is not aware of unlicensed content on its service, then the DMCA gives it some protection against that. And then obviously, as soon as it receives notice that there is infringing content on there, it needs to take it down to continue to receive that sort of protection.
Yeah. And so this is a bit of a kind of tangent side note, but when we started Mixcloud, we kind of knew that if people were playing other people's music, then we had to figure this out. We had to, make sure that we had the right licenses in place. And that's where we've been working with you, Aneesh, for many, many years, making sure that we have all these different licenses in place. But let's dig a little bit deeper in terms of kind of what other types of rights or sub-rights that one needs to get. So two that often come up are the mechanical and the performance rights. Could you walk us through kind of what those are and kind of how they work?
So I think all of these types of rights, they obviously stem back to copyright statutes, exactly what the law says. It doesn't refer to mechanical rights in the law, but the mechanical right is essentially, like we said at the beginning, when you own a copyright, you have the exclusive right to use it for the full period of copyright, however long that may be. And therefore, and it lists a number of things that is required that for to happen. Someone has to get your permission as a copyright owner. And one of them is reproduction of the work. So, and that is essentially the mechanical right. And the reason why it's called mechanical is because, I guess back in the days, way before streaming ever existed, it was the mechanical pressing of vinyl records was basically the reproduction of the composition containing those records. That was considered to be a reproduction, a mechanical reproduction, essentially.
Yeah.
And
I seem to I remember kind of reading into this once, and if my memory serves me correctly, it goes even all the way back to piano rolls in these kind of automatic piano players. And so if you wanted to make a copy of one, or there was kind of people out there kind of making copies of tunes on these piano rolls that were then sort of played in these automatic pianos. And there was some big court case back in the day about this. And then they determined that, okay, you can make a copy, but you need to get this mechanical right, which, for example, in the US, I think is sort of statutory, which means that the person who owns it can't refuse it, but you have to make a payment.
Yeah, exactly. I think, nowadays, the mechanical right, certainly in the streaming world, is a little confusing. It's been interpreted, even though the copyright laws haven't been updated, a stream in certain territories is considered to implicate a mechanical reproduction, which obviously, technically speaking, is so far from that mechanical reproduction of a piece of paper, essentially. But they say that the reproduction of the file on the servers of the streaming service creates a mechanical reproduction, which is why then, mechanical platforms need to obtain mechanical licenses. But a stream also implicates the performance of the work. So it's another kind of extrapolation of the law that existed before that hasn't really been updated, is that performance rights are essentially saying that every time. So one of the things in that copyright list is, reproduction of the work. Another one is the public performance of the work. So, and that traditionally would be, standing in front of a concert and performing the piece of music, and then, extending to playing it on the radio or playing in the background in a cafe. Those would all be considered to be public performance of the work in the traditional sense. However, certainly in the modern sense, now streaming is considered to be a blend of both mechanical reproduction and public performance in the form of, the transmission of the file from one to many, basically. So if you're starting with one file on the server, you mechanically reproduce it, then you electronically transmit it to millions of people. That is considered to be a public performance in the same way as playing it at a huge concert stadium or something like that.
I think that's is an interesting theme that I think has definitely come up through the years of kind of working with you and kind of just learning about copyright, how a lot of these laws and sort of where things originated is definitely pre-internet and even like digital computers and things like that. Some of these laws go back to sort of the 20th or even sometimes 19th century. And they come from these concepts that don't necessarily kind of map one-to-one to the world we're living in today.
No, not at all. I think, if anything, the legal landscape, or like the infrastructure for music, is so out of date with how much, and the music industry the way music is consumed has evolved so rapidly compared to other industries. And there's always been this. That's kind of why it's so complicated, and partly why I found it quite so fascinating at the beginning. But I was like, wow, this is a mess. Like, how is this whole industry operating on these laws that are completely out of date when most, other big sectors update, there's reform and new bills come through, and the laws are kind of like keep up to date with more modern technological developments. But music industry is somehow trying to like cobble its way through on these laws with these very kind of big extrapolations of completely out of date law.
Yeah, and then you kind of intersect that with the fact that everything happens at a national or jurisdictional level of each country. It might be different, and you just have this kind of infinite complexity of all the things that you have to consider. Lots
I mean,
of
I met many like
into it.
met many like even intellectual property lawyers who are very esteemed in their career and senior in their firms, who just like won't touch music because they're like, it's just, I just have no idea what's going on there. It's a mess. None of it really makes sense. It doesn't even seem necessarily always rational, the ways in the industry is having to work. But
well, let's talk about one more type of right that people might have come across or they might have heard of, and that's the sync rights. What are sync rights, and what should people know about that?
So sync rights is interesting because it isn't in that list in the Copyright Act. There isn't a separate the right to synchronize, music with audiovisual material. That's essentially what it is. It is. It's pairing the music with audiovisual content. But it does originate from the first one we talked about, the reproduction rights. So the reproduction can be mechanical rights, but reproduction has spawned what is now known as sync rights. So, but essentially, I guess why it's sort of split out is that that type of, it's usually a sort of contractual protection put in a lot of agreements. So in an agreement between an artist and a label, and perhaps between the label and the film company that wants to use the works, it's like a heavily negotiated term, mainly because it can be very valuable, to brands, to advertisers or film companies, TV shows. Music can play such a huge role, in shaping a film or a mood of a scene, and therefore there could be quite a high value put on getting the right song, and therefore quite a significant fee payable for it. And equally, from a sort of artistic integrity point of view, artists are quite protective over what they are happy to have their music like next to. I want to have they would typically want approval, because they'd say, actually, I don't believe in what that company is doing. I don't want my music to appear in an advert for it. So I think that's why it's sort of like sync is almost like an industry in itself. In many sync agencies at work, and music supervisors, like there's so many different careers you could have within the sync world alone based on that right, because again of the value that has come from music and audiovisual.
Yeah, definitely. I'd love to talk a little bit. We talked a little bit about covers, but I'd love to talk a little bit about samples as well, because I think maybe less so today, but there was definitely kind of an era in time where sampling in music was very prevalent. I think there was kind of maybe some misunderstandings or some myths that you could sample kind of like a little snippet or up to 8 bars or 5 seconds or something like that. So just to kind of give people clarity, like, is there any legitimate way to sample?
In short, no, not really, actually. Unfortunately, even there is no there's no time limit on what would be considered to be infringing or not infringing. So if you've copied someone else's work, that is copyright infringement. Without their permission, that is copyright infringement as a starting point. Now, you would then be you could then be on the defensive to say, oh, it was so tiny that it was not a substantial part of the original, that, to try and defend the accusations of copyright infringement. But, as to whether it was a substantial part of the original piece that you copied, that could be, I think there's cases from very tiny sections that maybe have been looped throughout the song. So it's a qualitative and not just a quantitative assessment in terms of what is a substantial part, whether you took enough of it for it to amount to copyright infringement. I guess there's been many famous court cases about this over the years, sort of Marvin Gaye, Robin Thicke, and the Ed Sheeran one, and we get involved in quite a lot of that type of work as well, and sometimes have to involve forensic musicologists. There's a few famous ones who will basically look, they will look at the two types of copyright and make an assessment whether it's infringed. And one, I think they can do almost like with a program. They scan the actual sound recording to see whether the audio fingerprint shows that it actually used the original, even if it's been heavily manipulated. I think you can do that when you have a sound recording file. But with a composition, then they need to be, they know music structuring, things that are commonplace and things that are original, and they have to make that qualitative review of whether something is copied or not. It's really interesting reading the report sometimes that those types of musicologists do. But yeah, I think the summary there is, get permission before, because if you kind of do it anyway and you try and seek permission afterwards, you will usually end up having to pay more or lose more of your income from the song. So I had quite a few instances where, a client might be like, oh, I had this track in, it did pretty well. I didn't think it would do well, but it did pretty well. And then when it does well enough, someone knocks on the door and says, hey, you've actually sampled this from my song. And actually, because it's an infringement, you didn't ask me in the first place. I want 100% of the publishing rights on this. And, otherwise I'm going to tell you to take it down. And then there's the MCA.
And these can be quite, like you mentioned, some of the cases you mentioned, quite high profile, right? Like the Marvin Gaye, Robin Thicke one. I think that went to one of the larger courts. And I believe that one wasn't even the sound recording. It was just sort of like how similar was the composition and the notes. Even if it wasn't identical.
That one was probably not a good example of necessarily a great verdict, although I'm a big Marvin Gaye fan. I think there was trial by jury, jury who aren't specialists in copyright law. It seems kind of bizarre. That necessarily something as complicated as, composition, constructure in terms of whether something is substantial to the point of copyright infringement doesn't seem to make sense to be something to be trialed by a jury. And because it's not really necessary whether it sounds similar, that's not what you're looking for. You're looking at for whether there is proof of copying and whether it was, once you analyze the composition on a sheet of paper, is the structure the same? If it just has a similar vibe to it, that's not enough.
Yeah, definitely. One other maybe misunderstanding or myth that I kind of sometimes see going around is this concept of fair use. Some people sometimes will upload things and say like, it's just fair use. I can get away with it. Do you want to kind of give people a little bit of an overview of what fair use is and how it works?
Yeah, I think fair use is widely misunderstood. I guess people hear it online and think it's a sort of blanket defense to using copyright. I think in the US, there's sort of a limited doctrine of fair use for certain non-commercial purposes. And there's some exemptions for like parody or commentary or criticism, educational purposes and things like that. But, any type of commercial use kind of quite quickly falls outside of the remit of fair use. I think in the UK, there's a similar kind of copyright regime called fair dealings, basically the same thing, but it's even more restrictive than the the sort of fair use doctrine in the US. So yeah, again, for like purposes of news reporting, perhaps there's some exemptions there, but I would tread very, very carefully before, trying to make any arguments of fair use.
Yeah. So I think that the takeaways on those two topics is basically don't try and claim it's fair use. And also, if you're going to use a sample, seek permission up front rather than asking for forgiveness. And maybe it's also worth mentioning just on that note that there are increasing number of kind of sample packs and sample providers and tools like Splice that kind of, make these type of things available. Obviously, if you really want to sample John Coltrane or Love Supreme, then, there's only one place you can get that. And so you're going to need those permissions. But in some ways, kind of, the more kind of unique and rare it is, the more you have to have those permissions. But if you're open to exploring just more, I don't want to use the word generic because it kind of puts them down, but kind of different samples that maybe aren't attached to or come from a famous song, then you kind of open up more possibilities.
Yeah. I think, the bigger the song is that you use, the more you're going to have to pay for it, of course. I think it's definitely important to not get too far down the rabbit hole of like completely finalizing your track, ready for release. You're like, oh, I'm going to go and get this cleared now. Because it may be, if you go to the Coltrane estate, it's probably going to be a no. I think they say no to any sampling of Coltrane's material. So, and, or it could be very expensive, and some copywriters will just say, no, I'm not going to agree to this unless it's a very substantial fee. It could be an upfront fee and plus a split of the income from it.
Yeah.
So
because they can literally pick a number, any number that they want, right?
Yeah, exactly. Yeah. I think probably on sampling, there's maybe one useful, I wouldn't say trick per se, but, don't sample the actual original sound recording, because any amount of that sound recording is being used requires a license. If you replay the sound recording, you're no longer copying the original sound recording. So you no longer need to license sound recording. You still need to license the publishing rights because you're playing the composition.
Just to interject for just 1 second, when you say replay, you mean sort of like with a live instrument or something, re-record. Yeah.
Exactly. Re-record it, figure out what the instruments that we use, see if you can make the same sound again. I mean, perhaps don't use an AI tool to recreate. That carries its own problems, but
we'll come to that.
We'll come to that. But yeah, I mean, and then, if it is a very small, insubstantial part of the composition, perhaps you don't even need to obtain the publishing rights there. I mean, that's debatable, I'd say, but at least you're only going after one permission, the publishing. It's quite a common route for a lot of producers to say, okay, we like this, we want to use it, let's replay it in the studio, and then we'll just clear the publishing instead of clearing both master and publishing.
Yeah. And so I think another kind of area to maybe explore a little bit is kind of just in terms of like artists, bands, producers, people kind of collaborating informally. A lot of this stuff happens. I'm making a track with my friend or something like that, and at what point would you counsel people to kind of start to think about copyright? Well, is there anything that they should maybe put in place before they're sort of collaborating? What do you generally tell people when they're kind of in that creative mode?
Yeah, I mean, I think it's quite difficult because you don't want to be a vibe killer, by being the person's like, hey guys, before we start jamming, can we all like agree?
Sign this piece
of paper. Yeah. And then you probably won't even jam then. Everyone will be like, what the hell? Like, okay, forget this, man. It's over. So there's a bit of a common sense approach there. Like, obviously, on the one hand, let the creative juices flow and don't get too bogged down in ownership splits. Let's see if you can, the number one priority is to like make something great, that to share with people. But I think then it is kind of important to be mindful that after you've made that, and if it's fixed in a medium, copyright subsists, it exists, and you all jointly own it. And Therefore, no one can do anything without it without the other person's permission. I mean, so you require unanimous agreement. And that's one thing. And, but also it may, in terms of your ownership contribution to it, you might want to work that out sooner than later. So if it was you and you were collaborating, it was going to be your record and other people were contributing to your record, you might want to kind of, I guess it depends on the circumstances. If it's your record and other people are contributing, you might want to be clear about like what they're going to get as part of your record up front. Because otherwise, if you leave it too far down the line, they could potentially stop you from releasing it because you have not got an agreement on whatever share they might have provided. So it's, I think it's good to be clear. I mean, if you can be clear before the session happens, be like, hey, I'd like to, contribute to this. This is what I'm offering. Obviously we'll revise that in good faith if it turns out we use more of your contribution than we expected. But
but is it fair to say that every contributor essentially kind of has a veto in the sense that they are one of the copyright creators?
Yeah, absolutely. I mean, if they contributed, again, back to the substantial part, so that there's sufficient originality in what they contributed for there to be copyright in their portion of it that they contributed or to the overall song, then they are deemed automatically a joint owner of their copyright. So they will have a veto over any of those, and it's being used in any other way.
Yeah. So I think feels like the takeaway there is kind of be honest and have that conversation. Sometimes it's maybe a bit of a vibe kill or, it's kind of a bit, academic up front, but it's just always easier than, having to do it kind of after a song gets released and maybe it does really well. And then you kind of have this kind of frustrating problem that you have to kind of sort out and fix.
Yeah, exactly. I mean, sometimes it can be quite useful to do it shortly after the sessions while it's fresh in people's mind. And you can remember, oh, yeah, okay. Or like once it's been the first mixes come through, you're like, okay, this seems like a good, reasonable proportion. Or even have a sort of default. Let's say, look, we can't, in the avoidance of any disagreement, let's just say it is split equally. And then everyone can do register their own share and collect income from it. But
yeah, exactly. All right. Well, let's move on, shift gears a little bit to the topic of AI, which is obviously a very hot topic today. And you kind of mentioned it in passing, but some of these new tools that are coming out, whether it's Suno or Udio, for folks that kind of maybe just new to them or aren't quite aware how they work, much like a lot of the big, large language models like, ChatGPT or Anthropic's Claude, they will be trained on music copyrights a lot of times. Now, there's a lot of kind of, let's say, gray area around what they've been trained on, whether or not it has infringed other people's copyright. Is training in and of itself an infringement? Because technically, are you making a copy? It's kind of maybe a bit of a open to interpretation or a bit of a gray area. I do know, though, that recently GEMA, which is the sort of collective music rights organization in Germany, did win a lawsuit. I believe it was against either Udio or Suno, one of the two. And so, the courts are starting to form opinions about this. But I guess there's sort of like two sides to this question, right? There's one is, are you an artist whose music has been trained on? And then the other side is, if you are thinking of making music with these tools, what are the kind of copyright sort of implications of that? So maybe let's start with the first one. If you're an artist and you think that your music has been used in training one of these tools, do you know if there's anything that you can do today kind of to check that?
I guess the trouble is with AI generated music based on training data of other music. By the time a lot of these platforms spit out the output, and if the output is then uploaded to a service and you listen to it and think, I think someone's used AI to regenerate a piece of my music. It's very difficult to trace. I think that's part of the problem. It's inherently difficult to trace where did it come from? What was the original training data that was taken? And even what platform was used to create the AI generated version. But I mean, I guess the basic principle still exists that if you think, presumably if it sounds like your music, then, and you feel like, but it sounds like my music, but some AI has been used to manipulate it. Well, it's still, if it sounds like your music, then it's possible that it still copies the composition, underlying composition in the publishing rights, and maybe even some of the sound recording copyright. So there's still the traditional kind of recourse there for takedowns, etc., as you would have from wherever the track is being exploited. And if you became aware that any of your music was on the AI generative AI kind of music service, say for example, if you went on one of these services and typed your artist name in as a prompt and said make some music like Nico Perez makes, and it came up with some music that sounded like your music, then I think it's evident then they're probably using your training data on their back end for their users. So I think in a similar circumstance to other services, you could issue them DMCA takedowns, or in respect of your works, and have them and request them for them to be deleted from any training data that they have.
Yeah, I know that there's some people kind of working on initiatives to sort of have a do not train registry or signal.
Mm.
Actually, one of the previous guests on this podcast, by the name Matt Dryhurst, I think it was episode number 10. He collaborates with his partner Holly Herndon a lot, and they do a lot of kind of work around pushing the boundaries and what's possible with some of these AI tools and things like that. And they have a kind of side project or project that they're collaborating on. I think it's called spawning.ai. And a lot of that was around, making it a little bit clearer what these models can train on and what they can't. Now, obviously, I think that there's a kind of a big, maybe it's a moral or even ethical question of like, should the creators have to opt out, or should it be opt out by default? And I think a lot of that is probably going to be decided in the courts, and it's still kind of in some ways unresolved at this time.
Absolutely. I think the UK was taking a position of you'd have to opt out, and then maybe it's U-turned on that in terms of what its legislative position is going to be. But yeah, still all completely unknown. Everyone's just guessing. See all these panels at various music conferences talking about this stuff, and no one really knows where this is going to end up.
The jury is literally still out. So
yeah, literally.
We'll have to see where it goes. But what about the other side? What about I'm making music as an artist, producer, band. I use one of these tools like Udio, Suno, one of the others. Where do things sit in terms of, do I own the copyright? Does the kind of platform own the copyright? Do you know how things sit in that regards?
Yeah, I mean, in many jurisdictions, copyright, requires human authorship. So something that is purely AI generated may not qualify for any protection at all. However, to the extent that a human is using an AI, generative AI service, to shape the music and, arrange it and give it directions, then potentially it is being used as a tool, like any other music tool that could be available to speed up the process of making a piece of music, and therefore you would be the author of that piece of music. I mean, obviously, what's completely undecided at the moment is where is the gray area. Where does that line sit? At what point does it what point is it considered a tool, and at what point is it considered to be purely AI generated? Like, how much does a human need to do for it to suddenly qualify to have been created by a human being? And that's just kind of wide open for debate at the moment, really.
Yeah, I guess if you kind of put in a prompt and say, make 10,000 hip hop songs, is that legit? But if you were to say, can you help me kind of come up with 3 different hi-hat variations that feels like not too far away from what you can do in, Ableton or Splice or something like that, and just kind of making that process a little bit easier.
Yeah, exactly.
Yeah. Yeah, it'll be interesting to see if it is even possible to kind of put a line in the sand somewhere or not. We'll see.
Probably. I mean, I guess that like all these things, there won't be any sort of statutory line in the sand. It will just always gets tested in the courts. So it'll only be when there is one of those edge cases and that there's enough money on both sides that people fight it all the way that judges will be forced to make some sort of assessment on these kind of difficult subjects. But hopefully, as long as they don't settle out of court, which most of the time they do, so we don't end up with a definitive answer on it.
Yeah. Speaking of which, actually, you have yourself been involved in a few court cases. I know that you worked with Four Tet, an incredible electronic artist from London, and there was a case where he was basically fighting his old record label because they were essentially kind of interpreting his contract to be what it was sort of when it was originally written back in the day, pre-music streaming. It was in the era of kind of iTunes downloads and things like that. And I think that that's in some ways like a classic tale. We've kind of seen it time and time again of artists or bands kind of feeling like they've got screwed over by the record label, and in some cases definitely legitimately have. So I'd love to kind of just hear your take on what artists and bands and producers and creators should think about when they're considering this idea of, either signing to a record label or signing to a publisher.
There's a lot to consider. I think getting an offer from a record label can often feel very exciting to begin with, but it's often a very long-term relationship, and perhaps a relationship could be longer than you live. If you talk about if you're assigning rights for life of copyright, and if that is for 70 years from the day you release, if it's a sound recording, and actually 70 years after your death, if it's publishing rights, it's an incredibly long time. Most of the time, if you have children, they're the ones who are going to be hopefully living off receiving your royalty statement. So, and I think young artists don't necessarily always think about that. They think about short-term things. They think about the advance. They're like, well, we get a big lumps of money. I haven't got a check like that like before. Most people haven't, So yeah, I think it's the key kind of most important things to think about, I'd say, from record deal are like, remember most of the time they're exclusive recording deals. Means that anything you record, even, I've seen cases some people have had like a YouTube channel, and like technically any recording you make of your performances will be owned by the record label for a period of time. So, and that means, can I collaborate with this other artist? Can I feature on this other guy's album? All of those things you're going to have to get permission from your record label, because you have to exclusively record music for the label. I think that one, even with quite experienced musicians, they forget that that's what the exclusive recording agreement says, basically. And then even after you're out of that sort of term, as they call it, with the label, so you've released a few albums with them and your deal is up and you're out, the label will still continue to control, or even own the rights to that music for probably a very long period of time, anything from 5 to until in perpetuity, forever. So I think it's important. That's another kind of like key area to think about and negotiate if you can. Then there's like other areas of income. How are you being paid? Are you being paid on a profit share basis, or are you being paid on like where you have to stand behind all of the costs that are invested into the putting the record out, the marketing, etc., or are you being paid on a royalty basis where maybe the label swallows all of the marketing costs and you just have to recoup your advance and to pay your royalty. And in publishing, I guess it's similar, but the rates are all completely different, and the way that's structured is quite different. But Similarly, the rights period, how long do they control your rights? What are they doing for it? What approval rights do you have over things? Yeah. I guess all of this probably sounds to the average artist is it's pretty perplexing. And some record deals are sometimes, I think, intentionally complicated to confuse. Yeah, maybe that's a cynical viewpoint, but I definitely read some. I'm like, how is anybody supposed to understand this? And that's not to say there's a whole band of labels that are trying to do things differently and make agreements very simple and easy for artists to understand. And we have a lot of clients that have asked us, can you make a deal that an artist can actually just read and understand themselves?
Yeah.
We'll try.
So that they don't need a lawyer.
Yeah. But that said, I would given the length of unless it's a very small thing and you've been clear about it, only the rights you're granting only being for a short duration, I would, if it's an important piece of work for you and if it lasts for a long time, just get some advice. And most of the time, you should be able to find a lawyer who will give you some quick and free advice. And if it is quite a substantial deal, quite often the label, the publisher will actually advance your legal fees against your future royalties. So, maybe some artists don't always know that. They don't contact lawyers because they're worried about it. They're like, I don't know, lawyers expensive. I think I'll just sign this and just not go there. And then actually we pick it up and we're like, damn, I wish we had talked to you before because we could have made this look a lot better. And actually they would have covered our costs in doing that, or maybe we wouldn't have charged at all because it was just a small piece. If it was just tweaked a couple of things. So I would say music contracts are inherently very complicated and you just do need specialists, a specialist steer on them, just to check what benchmark is that in line with industry standard? It's hard to know unless you've done many, many deals.
Yeah, absolutely. One of the guys from our team who actually helps edit this podcast, Yemi, he's writing an article for our blog about this topic. And I was talking to him about it and sort of, I think conceptually the way that at least I think about it is it's a trade-off at the end of the day, right? If you're a struggling artist and, you got to pay rent, you got to eat, you got to pay for the bus, whatever it is to get around. At the end of the day, are you willing to make that trade? And what are the terms of that trade, right? Because you are giving up something. If you get an advance, if you sign a deal, it's exciting, like you said. It's, oftentimes a big milestone or a big step. But understand that you are trading something. You're trading something away. And so the question is, do you want to make that trade? Is it a good trade? Is it a bad trade? And every person will have a different point of view on that. But at the end of the day, another way to kind of think about it is how much do you believe in yourself and how far can you go on your own? And there's quite a lot of similarities actually with building a startup like Mixcloud, which arguably at this point we're not a startup anymore, but it's sort of at the end of the day, if you can go far by yourself, you're going to have better terms in that trade. Maybe you don't even need to do the trade at all. And I think increasingly, a lot of record labels are actually looking for artists who've released, built up a following, done a lot by themselves. I think Stormzy is a good recent case of somebody who went really, really far by himself. And then when he finally signed a deal, I think it was with Warner, he had just a lot more ability to negotiate, get a lot of better terms in that trade.
Yeah, 100%. I think record labels are finding it more difficult in the modern age than perhaps they used to. And the sort of risk reward has changed. The amount of music that's out there has changed, and it made it more difficult for them to say break new music where they could have dominated charts and things like that. But and as a result, yeah, you're right. They're not signing things before anybody's heard about them. As you used to hear, I saw this band playing, I just went up and offered them a deal and signed them, and they ended up being this huge act. It's they're looking for things that have actually already they'll check their monthly listens on Spotify or whatever, and they'll check their Instagram. All right, how well are they doing already? How big is their fan base already? Before we then so we know we've got something to work with to build, and then put all our marketing and investment into, rather than kind of starting from scratch. They seem to be the bigger labels anyway, so it's only less willing to do.
And then I guess another kind of evolution that's sort of come hand in hand with that is that some labels are now kind of offering these services type deals where actually you might be able to retain your own copyright, but it's structured as a service type of deal where, maybe they do the marketing for X fee or X percentage or whatever it may be. And equally on the publishing side, I know there's some publishers like Cobalt who they let you often retain your own copyrights. And so I think you're right. It feels like we're sort of evolving in a direction where probably more and more artists and songwriters will retain their copyrights, but maybe the structure of the business deals changes slightly. So they're kind of more thought of sort of like service deals in a way.
Yeah, definitely. I mean, I think those types of deals are definitely becoming more popular, because artists nervous about these long rights periods, and they say, okay, but I can potentially just do this shorter term deal. I keep the copyright and I just pick the services that I need. I mean, I think that at the same time, I wouldn't want to necessarily discredit the amount of effort that goes, that goes into launching a, globally known artist these days, and how much effort that has to come from a label, or that might come from how much investment that has to go into it from a record label necessary to get someone to a certain level where they could really where music can continue to support them for the rest of their life. So it's sort of like, I mean, I have this all the time with artists getting both deals side by side. Which one shall I do? Short-term one, which is I'll probably have to do more legwork myself. I'll get less funding, but I won't give away the rights. Or longer-term one, there's no real right or wrong answer. The longer-term one, the reason why the rights period is so long is quite often because labels are going to invest a huge amount of resource into trying to make a music into something that is on a much higher profile than maybe you might have been able to achieve through bootstrapping yourself or even working under the service kind of deals. So there is really always a bit of a trade-off. It's a difficult thing to be very definitive on. I don't think there's any I think that maybe the narrative that although people, having worked on that case, people think my narrative might be labels are bad, the artists get short rights period. Not necessarily the case. It's sort of arguing in that case purely about what the contract said and what it was missing and how it didn't have a crystal ball into the future and what is the fair thing to do if it didn't specify what a rate should be on streaming. I think, but more broadly, whether rights period should be long or short, or rates on streaming and this and that, it all comes down to exactly what he's kind of saying. It's the bargaining position really between what are you getting in return for giving that away. Maybe it's okay to give that away, but what are you getting in return? And you want to see, I'm giving away a very long rights, but I want to see what that marketing spend, how are you going to get me to that level as an artist? And, so it's making sure the exchange is fair, and the exchange could be fair on so many different types of structures, I think.
Yeah, definitely a lot of food for thought there. I think you're spot on that there is no kind of right answer to this. It's not like all labels are bad or, labels are great. Just sign any deal. It really depends on the deal, the person, where somebody's at in their life, all these different kind of variables and stuff. I'd love to kind of wrap it up then. We've covered a lot of ground here. We've covered, the origins of copyright, the different types of music copyrights involved in a musical track or song. We've talked about fair use. We've talked about sync licensing and AI, all these sort of things. And I'm just curious, is there kind of any major kind of overarching themes or any kind of final thoughts from you in terms of, I guess takeaways really that somebody kind of listening to this should think about kind of before the end?
Yeah, I mean, I think Biggest takeaway is that to remember that your creative expression is a piece of property, really, and it's important to obviously protect it and be careful about giving it away. Don't and think about things in the long term, and think about it as in the same way as any other piece of property that you might own for the rest of your life. And so, treat it with care, but at the same time, and I guess share it in the right way. So there's lots of ways to get it out there and have it heard and shared with other people, but make sure sort of the appropriate mechanism in place so that it's not taken advantage of in any way.
I love it. Very, very wise words, Aneesh. Thank you. Thank you for joining us. I appreciate you spending the time. Maybe one last question. If people want to kind of find out more about the work that you do or, Brilliant Corners, Giant Steps, do you want to kind of maybe mention a few places where they can find you online?
Yeah, sure. So our website is ap@associates. Too many APs there. ap@ap.associates. No, ap.associates. Sorry, I forget. That's my actual email, ap@ap.associates. So, yeah, but if anyone wants to find out anything, you've got my email. You hit me up.
Awesome. Good stuff. All right. We'll wrap it up there and leave it at that. And
cool.
yeah, hopefully
Thank you for having me
again sometime.